Hello, all you cool cats and kittens. Sorry, I've been wanting to do that on a webinar video for some time now, so thank you for indulging me. Let me get that out of my system. For those that don't get the reference, good for you for not falling for the peer pressure that the rest of us went through and watching that mini-series. No, I'm not the Tiger King, although with a little more time without a haircut, I'm going to have a nice mullet growing back here soon. No, I'm Jeff Stinson of the Stinson Law Firm. Thank you all for attending our webinar today entitled Taking Control of Your Estate Plan, or what I've subtitled as Estate Plan for Happy Days. And you'll find out in a little bit why I refer to it in that way. This was actually a seminar that we'd had scheduled several weeks ago in conjunction with Lake Meadows, an assisted living facility currently being constructed in the Fishers area. But we weren't able to have that live program due to the pandemic. So we thought we would switch things up and offer it instead as a webinar. So again, thanks for attending today. So let me get started here. Get our screen up. Estate plan for happy days. Why are we even talking about this estate plan stuff? I think some people, when they think of estate plan, they may think of somebody or a family like this. Yeah, so estate planning for a family like the Ewings, a family that has immense wealth, that has a family business, that has constant family conflict. But I can tell you, yes, the Ewings need estate planning, but even a more modest family, such as these folks, can also benefit from estate planning. I think you all may probably remember the Cunninghams. From the hit show Happy Days several years ago. We had, as you recall, Howard and Marian and their three kids, Richie, Joni, and Chuck. And yes, Chuck. Some of you may not remember Chuck, but Chuck was the oldest Cunningham child that had about a season with the family, and after that kind of disappeared. But, you know, the Cunninghams being this good, wholesome family where everyone gets along, there's no problems that can't be resolved without a stern lecture from Howard or maybe a home-cooked meal by Marian. But by diving into this family, we're going to find that things aren't always what they appear. We're also going to figure out what happened to Chuck and why Howard started in later episodes of the series, only referred to his two children, Richie and Joni, rather than Chuck. So let's fast forward to Howard and the Cunninghams today. And we'll start with Howard and Marian. Howard and Marian are kind of your typical middle-class couple. They own their house. They still own Cunningham Hardware, that hardware store that Howard worked in for many years. Howard also has an IRA. It's got about $100,000 in it. And they have some various bank accounts and CDs. In addition, they both have a term life insurance policy on their respective lives. Now, they don't have any estate plan documents. They've never estate planned, other than there is a power of attorney that Howard signed about 6 years ago when he went to the Leopard Lodge National Conference so that he could give some authority to Marian to handle some bills while he was gone. Really, the only other kind of estate planning they did make Richie joint owner of their checking and savings account at the suggestion of their banker, and made Joni the beneficiary of their life insurance so that she could take care of their funerals when they passed away. About the kids, well, let's find out about Richie. Richie's a successful movie director in Hollywood, and Joni's still married to Chachi, and they've actually been running the hardware store since Howard retired. Fortunately, although their marriage is still intact, they've had some rough times. It's been kind of a contentious marriage. What about Chuck? Well, you know, most of the family hadn't heard from Chuck since he left for college 40 years ago. Only Howard really knew what happened to Chuck. Chuck unfortunately dropped out of college shortly after getting there to become a roadie for the Grateful Dead, where he kind of became addicted to all sorts of substances. Howard tried several times to help him, but after a while he kind of gave up on Chuck and had distanced himself from Chuck for several years. They hadn't really heard from Chuck for a long, long time, up until about a year ago, when they did learn that Chuck had passed away. But he left 2 kids. His son Chucky, is 18 and a senior in high school, and his daughter Sarah is 25 and disabled. Now let's not forget about one other Cunningham here, and that is Arthur. Why he's not a blood relative, Howard and Marian still adore Arthur and have considered him their son all along. Arthur's currently a teacher at the local high school and regularly checks in on Howard and Marian. In fact, he's the one who actually usually takes them to medical appointments and helps coordinate their health care. Now, as I mentioned, Howard and Marian really didn't do much in regards to estate planning. They didn't see the need for it. They thought it was for wealthy people like those Ewings down in Texas. They, though, greatly appreciated Arthur's assistance in taking them to the doctor and often relied on his advice when making medical decisions. But it never really occurred to either of them that they would need any type of planning. They didn't really think they'd ever need long-term care. I mean, both sets of parents passed away of short-term acute issues, and nor did it really occur to either one of them that they might be incapable of handling their affairs for a period of time and would need some help. They kind of figured, since Joni been in the hardware store for several years, that she just assumed ownership of it when they passed away. And while they were happy to know that Chuck's kids were doing well, due to Chuck's estrangement, they really didn't know them all that well. So really didn't anticipate them having any role in the family once they were capable or gone. Now, unfortunately, in December last year, Howard suffered a stroke, leaving him completely incapable of self-care to make his own decisions. He hadn't at that time taken his minimum distribution from his IRA for 2019, so Marian sought to do that for him. She remembered that power of attorney he signed when he went on his lodge trip a few years ago and sent that to the IRA custodian, requesting that the minimum distribution be delivered. Fortunately, the custodian refused to recognize that power of attorney because it only gave her the authority to handle banking transactions, paying bills, managing the checkbook. She didn't have the authority to do anything else, like take a distribution from a retirement account. So she had to petition a court for authority to be appointed as his guardian, just so she could take out this retirement, but also to handle his finances in general. Fortunately, after a few months, though, Howard succumbed to his illness and passed away. Didn't get any better for Marian, though, because yes, she did get the house and the hardware store and the bank accounts because those were in joint name with her. And she did inherit his IRA because she was the primary beneficiary. But the life insurance that was paid to Joni, she didn't use that for her dad's funeral. Instead, she used that money to take her and Chachi to a marriage retreat to help try to mend their marriage. So since that money that was earmarked for Howard's funeral wasn't there, Marian had to take money out of their savings to pay the funeral bill. Marian did hold up reasonably well after Howard's death, but geez, some more tribulations did hit her. An actor was injured on the set of one of Ritchie's most recent movies, and he sued Ritchie and received a substantial settlement after a much publicized lawsuit. Most of Ritchie's assets were tied up in judgment liens. Shortly thereafter, Marian started receiving calls from her utility companies and her credit card company that recent checks she'd written had bounced. She thought this was really bizarre because she knew she had more than enough money in that account. But upon investigation, she found out that one of Ritchie's creditors put a bank levy on her checking and savings account since he was listed on there as joint owner. Fortunately, she had to hire legal counsel to get that cleared up. And after some time, the attorney was able to convince the creditor to release the lien, but only after she'd spent some money to get that fixed. It wasn't long after, too, that Arthur started noticing Marian exhibiting some bizarre behavior. She would forget his name. And he also noticed when he'd come over there, he'd find empty pans sitting on the stove when the stove burners were still on. And she'd often talk about Howard as if she'd forgotten he passed away. One day she even mentioned that she was waiting for Joni to come home from her junior chipmunks meeting, as if Joni was still a child. So Arthur decided one day he would schedule a doctor's visit for her. And the doctor diagnosed her with Alzheimer's disease. But after that, he refused to give any more information about Marian to him because he wasn't family and he had no other legal documentation. So Arthur called Joni and Richie to tell them that what the doctor said about Marian and her Alzheimer's diagnosis. And they all agreed that she needed some care. Arthur had some experience in this area and protecting assets for someone that was in need of long-term care and accessing public benefits assistance to help pay for that care because his mother-in-law had been through that a few years ago. His wife's family had hired a local elder law attorney to help protect those family assets, and Arthur suggested they do the same, which Richie and Joni agreed. 2 weeks later, Joni and Arthur met with the elder law attorney while Richie attended by phone, and the elder attorney explained how both VA pension benefits and Medicaid benefits can often offset the cost of expensive long-term care. The pension would pay a monthly cash benefit, while Medicaid kind of operates like health insurance. He explained that although both programs have a financial eligibility requirement, a legal plan to either move assets into legally created safe harbors under those programs or through strategic transfers can help protect the applicant's assets. So although planning before this crisis probably could have saved most of Marian's assets, he could still protect at least half of her assets. The biggest impediment, though, was since Marian had no legal documentation, no estate plan, no one had the authority to implement such a plan. The whole plan would require the appointment of a guardian and the approval of a judge. Fortunately, though, the judge approved this plan and appointed Richie and Joni as co-guardians. Although a dispute quickly arose between Richie and Joni as to which assets would go into the protected half and which would have to be spent on Marian's care. See, Joni wanted to protect the hardware store at all costs, while Richie, he was more inclined to protect her cash in the home. Now, Arthur tried to kind of mediate this, but neither one budged. Meanwhile, Marian's hanging out there for a care cost bill of about $10,000 a month. Yeah, it just keeps getting worse and worse for the Cunninghams. They make the Ewings look like the Cleavers. When Marian passes away, Richie hires an attorney to be appointed as personal representative of Marian's estate. Without a will, though, the laws of intestacy dictates how her estate is divided, which is 3 shares. One for Richie, one for Joni, and one share to be divided between Chucky and Sarah, Chuck's kids. Now, Joni was expecting to receive the hardware store as Howard had always promised, and was surprised to learn now she's got to split that equally with Richie, Chucky, and Sarah. And so she tries to find enough cash to buy out the rest of her family, but just can't. So Richie has to sell the hardware store to Ralph Mouth, and Joni has to find a new job after 25 years. Don't forget about Arthur, though. He's bummed because he always considered himself a Cunningham child, and it's kind of upset that even though Howard and Marian always anticipated treating that way, he isn't because he's not part of the law of intestacy, so he's not receiving a share, and the other family members are unwilling to share their inheritance with him. When Richie goes to distribute the shares to the beneficiaries, there's even more problems that arise. Richie's creditors immediately seize upon his share, leaving him with nothing. With no job and an already rocky relationship, Chachi divorces Joni and takes half of her inheritance in the marital settlement. Now, Chucky, he's ecstatic that his grandma that he barely knew left him $60,000, but he uses that money to go out and buy a brand new hot rod to impress his friends at school. And after receiving her share of the assets, Sarah loses her SSI and Medicaid benefits, and her guardian ends up expending most of her inheritance on her care before reapplying for the benefits that she had lost. Doesn't stop there though. Joni's beneficiary of Marian's life insurance tried to use that money to buy Chachi a new motorcycle to try to convince him that their marriage wasn't all that bad. Richie tells the attorney, now wait a minute here, these were supposed to be used for mom's funeral, but as the attorney explains, there's really nothing they can do because Joni is the beneficiary. Okay, so that was a mess, wasn't it? Why most of my clients aren't going to see all of those issues, rest assured, most families will have some one of those issues that arise in their own planning. It's going to make for the need for planning. So what did we learn from the Cunninghams about planning? Well, the first thing is plan for the worst and hope for the best. Like I said, not all families are going to get hit with all of those horrible issues that the Cunninghams had to go through. But chances are one of those issues could arise during your lifetime and after your passing. So I always use the motto, plan for the worst and hope for the best. We always joke around here that my staff probably going to be down the road several years, and that's still going to be ingrained into their head. The other thing I tell clients is I'm the paid pessimist in the room. We're looking at what's the worst thing that can happen, plan for that, and hope that that never happens. But those are the things we want to plan for. We want to identify those potential issues and plan accordingly. Something else we can learn from the Cunninghams: get help. Think of a couple of situations here that happened with him. Let's take the situation with Arthur. They wanted Arthur to be, he's part of the family. They relied on him heavily when it came to making healthcare decisions. But the minute that they were incompetent, incapacitated, Arthur had no say in anything. It was left up to Joni and Richie. And Richie's in California. Joni was busy with the hardware store. So Arthur kind of got cut out of that situation where he'd had that role. Also, think of, they really wanted Arthur to be treated as one of their children. They wanted him to have a share of the inheritance. And he didn't get that without the planning. Think also to that well-intentioned banker. Remember when Howard and Marian put Richie's name on the bank account to make it easier for him to pay bills for Howard and Marian. But that backfired, didn't it? Because when Richie had creditors, all of a sudden their assets become Richie's problem. Their assets become part of Richie's problem. So another thing there is get help. Talk to somebody about your planning. Help put the right things in place for you. Why do we estate plan? I try to break this down into 4 reasons. The first being to have a say in what happens to yourself, your loved ones, and your assets. And we're going to talk a lot about those issues here in a minute. The second, minimize potential conflict between family members. You know, even the best relationships, when tensions and emotions are high because of a crisis, it's easy to fall into a trap of conflict, particularly when there's ambiguity. It's easy to say, well, I should be the one handling this issue, or no, I should be the one, or, well, mom really wanted us to do that. Well, no, that's not the way I remember it. Mom wanted us to do that. So planning can minimize any ambiguity and the potential conflicts that arise out of that. Planning can also reduce expenses and protect assets. Some folks will plan to protect assets from tax, death taxes, which probably at this point, most people in this video won't have to worry about an estate tax. But income taxes, some people will plan to reduce income tax. And we'll talk a little bit about a change to the IRA rules where you might want to have a estate plan checkup to make sure that change isn't going to result in your beneficiaries paying more income tax. Or protect assets from the cost of long-term care. Another reason why people plan. They don't want to see a family business or a farm or just an inheritance being completely wiped out because someone had a long-term care need. Or others might want to reduce just the administration hassle and expenses at their passing. And finally, We often plan to protect family members from themselves. Thanks to all of those things that happened to the kids, the Cunningham kids. There's some reasons why, and we'll talk more about that in detail here in just a few minutes. So taking control of your estate plan. You may not know this. If you haven't put pen to paper, if you haven't written your plan, you actually already have an estate plan. Indiana law has chosen your healthcare representative, for example. There is a list of priority of folks that get to be your healthcare representative, from a judicially appointed guardian to a spouse, to a brother, sister, to an individual's religious superior if they are part of a religious community. Indiana law has provided who's going to manage your finances. A judge decides through a guardianship who gets to do that for you. And Indiana law has even decided how to divide and distribute your assets when you pass. We call this the law of intestacy. But the point I always want to make to folks is, do you really want to leave your plan up to what a consensus of politicians come up with in the default law? Probably not. So take control of your plan. First step, select your team. Who do you want and who is most likely to respond in a crisis? And they generally fall into three roles: your financial management team, your healthcare decision-making team, and then the folks that are in charge of your funeral arrangements, your final arrangements. Now you want to make sure you're putting the right person in the right roles. The financial manager should be someone who manages their own finances well. They balance their checkbook, they budget, they track investments, they know when they need to get outside professional help to consult with. Your healthcare team is that person that I describe as able to be at the bedside, listening to what the doctors are saying and following your instructions or making decisions for you. Funeral planning team, those are the ones that are there to, if arrangements are made, just to schedule your funeral, to get you where you need to be, those types of things. Some bad reasons to put people in these places. My oldest should be here. Well, if your oldest is not good with finances, probably shouldn't be your financial team member. Or I don't want to upset this child because they don't have a role. Well, if they don't have a role because they just didn't fit, then you probably don't want to name them. Or maybe it's, well, my spouse has to be named. Maybe your spouse has some limitations and shouldn't be named. So those are all reasons you wouldn't want to put folks in the role. Right. After you've chosen who your team is, then you want to give them the authority. And this is where the estate plan documents, the legal documents come up. And we're going to talk in detail about those in just a minute. But along with that, you want to make sure you're also giving the team instruction, because it's one thing for them to have the authority. It's another thing for them to know what to do with that authority. So you need to make sure they know what your thoughts are with healthcare, what your thoughts are with managing assets, doing Medicaid planning or VA pension planning, things like that. So we're going to talk a bit about that here in a minute too. All right. So that authority, where does the authority come from? Well, for the financial team, they're going to get their authority generally from one of two documents, and probably both documents, belt and suspenders. One is the general durable power of attorney, that document that gives someone the authority to handle finances, or the other might be a living trust. And I'm going to spend some time talking about trust here in just a few minutes. The difference being, financial authority to deal with trust assets come from the trust document. Financial authority to deal with those other assets come from the power of attorney. How about the healthcare team? Well, the healthcare team is going to get their authority through either the appointment of a healthcare representative or appointment of a healthcare power of attorney. They kind of are the same, but a little bit different. And typically, I'm naming the same person that's in that kind of same role for folks. As part of the advance directive, generally you also want to give some instructions on what to do with that authority. If I have a terminal illness, I want you to do this or not do this. So that comes through the living will or life prolonging procedures declaration. And then if you're terminal, you can take that one step further and actually put in orders into your medical record on what type of treatment you want from that point of your life forward. Now, it's only in a terminal situation. And these are most of them through the post forms, physician orders for scope of treatment. Now, again, this is only terminal. When this law was first passed, I noticed there was some folks that weren't terminal that were all happy that they got their post form completed. And I had to say, that's great, but it doesn't apply to you because you're not terminal. But folks that have a terminal illness meet with their doctor and they can actually put these orders into their medical record. So there's the team, there's the authority. What else do you want to do when you're taking control of your plan? Well, you probably want to change the law of intestacy, that default disposition of your assets when you die. Here's an example. Many people are surprised to learn this. If I'm married, a lot of people assume that my spouse is going to receive all of my assets upon my death. But that's not what the intestate statute says. The laws of intestacy would say, my spouse gets a portion and my kids get a portion. I know a lot of people, that's not what they want. So there is just off the top one reason why to have a will. Also, taking control of your estate plan. Here's another tidbit for you. A will is usually insufficient to distribute your assets. I get a lot of calls that say, I just want you to create a will for me, Jeff. And I explain, well, it's a little more to that. You want to make sure your team has authority to deal with things, not just during your death, but if you're incapacitated. But also, a will is only going to distribute your probate assets. Now, what's a probate asset? A probate asset is that asset that is in your sole name with no beneficiary on it. Now, think about your assets and how they're titled. I'd wager that most of your assets are non-probate assets, not probate assets. And a non-probate asset is going to go to the beneficiaries of that asset. What are some examples? Well, one, the revocable living trust. And bear with me, we're going to get there in just a minute. Joint ownership. Doesn't matter what the will says. If something's in joint name with another, that surviving joint owner is going to get the asset. Beneficiary designation, an IRA or a life insurance policy is going to have a beneficiary on it. Doesn't matter what the will says. Those proceeds are going to be paid to whomever is listed as beneficiary on that contract. Or maybe you have something like an account with a payable on death designation, or you have a transfer on death deed, or maybe you have a limited liability company or a limited partnership. Those are all non-probate assets. And I'm going to say them several times here. As part of planning, we always want to make sure these things are all coordinated. The will's not only going to direct probate assets. So if your intent is, I want all my stuff to be divided by my 3 kids, we want to make sure each one of these silos has the beneficiary as the 3 kids. We'll talk more about that in a minute here too. Now we talked about, one, you plan just to take control of your estate plan. But another reason we talked about, I listed that some people will want to plan, is to preserve the resources. One, just simply might be ensure your team has the authority to plan to protect assets from long-term care costs in tax in a crisis. 2, maybe you want to be more proactive and do some planning to protect assets from estate tax or income tax. And here's where that IRA law that happened in January, the Secure Act, comes into place. And I'm going to end with that. So we'll get back to that in a minute. Maybe you're interested in just protecting a family business or farm or sum of funds just to preserve an inheritance. Think of like the Cunninghams and Cunningham hardware. People will estate plan to preserve those family assets from long-term care costs or taxes. Or others might just want to reduce those administrative costs and hassle that I referred to. And there's where they might create what's you might call a revocable living trust. And I think now is a good time for me to pause and kind of explain what a trust is. A trust is, ooh, that's kind of cool. I'll put it in front of me here. The trust is kind of like a holding tank. It's just a container. And it can hold all sorts of stuff. It can hold a house. It can hold a bank account. It can hold investments, stocks, bonds. It can be beneficiary of life insurance or IRAs. So it's kind of analogous to a bucket or a nest or a container. Now the grantor or settler, they're the one that builds this container. They're also the ones that creates a set of instructions on how to invest stuff in the container and how to use stuff in the container for other people. That person in charge is called the trustee. They're following those instructions. And then the beneficiary, they're the person that benefits from this trust. Now you'll hear all sorts of types of trust, an attempt to label trust, classifications. Trusts really are classified based on what they can do or can't do, or how they're created, or their purpose, or for why they're created, or who created them. But you'll hear labels like revocable or irrevocable, or living versus testamentary, or special needs versus grantor. But what we're focusing on right now with this revocable living trust is one that I kind of describe as your alter ego. This is kind of Clark Kent and Superman. This is you're the beneficiary, you're the trustee, you're the grantor. So the only difference between the trust and you is the things are titled a little differently, but they're for your benefit. So when we're talking about that type of trust in particular, what are some reasons why you'd want that trust? Or maybe differently, just back up. Why would one need a trust versus one would want a trust? Now, I know a lot of folks out there will tell you, you got to have one of these alter ego, one of these revocable living trusts, because you want to avoid the horrors of probate, or it's going to save you money, or the court's going to take it all, or it's going to avoid paying taxes, all your taxes, or the attorney keeps the attorney from taking it all, or that makes administration easier, or makes it faster. And why some of these have some validity to them, I can tell you, like for example, avoiding probate is not so much it's reducing costs. You still need an attorney even if you're not going through probate when you pass away. And yeah, it might reduce costs, but there are costs to setting up the living trust. So are those costs equivalent? Most often they are. But there are some fully legitimate reasons to avoid probate. Maybe you just don't want things to be public record. You want things to be private. Maybe you have a cantankerous family member that you know that because they're always complaining about something and they're going to cause problems when you pass away. Well, by not opening an estate with a court and avoiding probate, you've eliminated at least that forum, an open forum for them to express their concerns. Doesn't mean they can't still create havoc, but without that open forum, it does create one barrier to them causing issues. So let me talk more about this distinction between need or want. Here's some reasons you need a trust. You need a trust if you're wanting to protect beneficiaries from themselves, or you're wanting to protect family assets, like that irrevocable family trust to hold family assets to protect them from long-term care. Or you might need a trust because you're trying to minimize tax. Those are reasons why you might need a trust. You might want a trust, though, alter ego, revocable living trust, though, if you want a professional fiduciary and you want to give additional instructions to that fiduciary because they're a third party. Maybe you want to ease the burden of administration. Everything does go into this container, and so when the next person in line, they just take that container rather than going here, there, and there. Or what I often recommend for clients who have a variety of assets is to create one of these trusts just so you have that single receptacle that you can put your house and your bank accounts in, but also will be beneficiary of the IRA and the life insurance and maybe this other IRA and this other life insurance policy. So you've just got one single receptacle so that you don't have to, if you want to make a change to your plan, you're not going to every one of those silos and changing the beneficiary on all those silos. You just have to change it once in that receptacle. So I hope that helps folks kind of think through, do I need a trust in my estate plan or not? Now, finally, we talked about another reason here of protecting the family from themselves, another reason why we plan. So things like a beneficiary trust for minors or folks with special needs or just need support. So you're trying to get a beneficiary to accomplish a result, maybe finish college or something like that. Or maybe the beneficiary has marital problems or creditor problems. So, think back to the Cunninghams. There was Chucky who blew his inheritance on a hot rod, or maybe Howard and Marian would have preferred to use that for education. So a trust could have avoided that issue. Or Sarah, who had special needs, who could have put that money in a special needs trust of her own making, or Howard and Marian could have created one for her that would allow her to benefit from her inheritance and not lose those public benefits. Or maybe there's Joni, who we kind of figured there was already some marital issues here, so we would want to put that in her inheritance in a trust so that half of it doesn't go out in a divorce settlement. Or there's Richie, who maybe the minute that we knew he had all these judgments from the lawsuit, could have created a trust to hold his inheritance so those creditors didn't come and grab that the minute he received it. So those are all reasons why we plan. After we've developed a plan, what are some other issues to consider? Well, the first is, again, I've hit on this a couple times already, coordinating that estate plan, tying it all together. And that's one of the things that an attorney can help you do to make sure that you identified every one of these issues and tied it all together. Because, again, if your intent is, I have 4 kids and I want my 4 kids, everything I have, to have an equal share. All 4 of them get an equal share of everything. Well, then you need to make sure that your life insurance has those 4 kids as beneficiary. The IRA, the 4 kids as beneficiary. The will for the probate assets, 4 kids as beneficiary. Or if there's a trust, 4 kids as beneficiary. So you want to tie it all together. The last thing you want is, I put this kid as joint owner of this account, so they get that entire bank account, but that's not what I wanted. And then I forgot to put all the kids on the life insurance, so there's 2 on there, and so the other 2 don't get those proceeds. You want to tie it all together by making sure they all have an equivalent designation on every single one of those silos. The other issue I want to point to make here is, if you already have a plan, or once you put one in place, you want to review that plan and update often. Circumstances change. Your family members might divorce, or you might add a family member, or names change, addresses change, something as simple as that. Or maybe something more significant. There's creditor, all of a sudden you have somebody with creditor issues, or someone becomes disabled. Those are all changes of circumstance, or your circumstances change. You have a healthcare a diagnosis of some disease that you want to make sure your plan is up to date to accommodate those changes in circumstances. Or maybe there's been a change in the law, something that you may not be able to you're not aware of until you check in with that. So my rule of thumb is, if there's been a change of circumstance, or you just haven't had that plan looked at in 3 to 5 years, it's probably a good time to have it looked at. Read it through, have it looked at by a professional, make sure it's up to date with your circumstances in the law. In regards to law, here's a good example I told you I would get to. If you have a plan where you have an IRA and you've named a trust as beneficiary, and you haven't had that looked at yet, you really need to get legal counsel and look at that. In January, there was a substantial change to the IRA rules, where if a trust is beneficiary, that trust could be paying more tax all of a sudden than what was being paid before. So you want to make sure, there's just an example, to have your IRA designations reviewed because of this change in circumstances. All right, so that was our time machine there. Got a little ahead of myself. So now, by the miracle of our Back to the Future time machine, we're going to go back in time, and we're going to warn Howard and Marian that they really need to make sure that they do some planning to avoid any potential conflict within their family, and to ensure that their estate plan ensures that the happy days continue long after they're gone. So let's go back in time. Let's hear what they did. Well, one thing they did, they identified right off the bat that they wanted to protect the hardware business from the cost of their long-term care, and to preserve that as an asset for Joni so that she has a job long after they're gone. So they set up an irrevocable family asset protection trust and placed that in there. So that asset's protected from their long-term care costs, and at their passing, can be distributed to Joni. They also recognized, hey, Arthur's one of the family here. So not only did they execute wills to make sure that Arthur is treated as an equal to Joni and Richie, but they also executed that healthcare power of attorney, healthcare representative designation, designate Arthur as their healthcare representative so that he can continue to go to the doctor's appointments and manage healthcare long after they can't. They also put together a power of attorney that's general durable power of attorney, not just a limited for banking, so that everything can be handled by their agent, whether that's bank accounts or the IRA or even public benefits planning if either of them need long-term care in the future. And then they put in a few trusts to protect the inheritance for their family members. They put together a trust to hold Joni's inheritance so that if that marriage ends, half those funds aren't going to go away with Chachi. And knowing Richie had the creditors, they created a trust for him to hold his inheritance so those creditors can't take his inheritance away from him. And Chucky, yeah, I guess they did, maybe in the end they did decide Chucky and Sarah should receive a little something. So Chucky's inheritance went into a trust until he's old enough to be able to make good decisions with that money. And Sarah's went into that special needs trust so she can get that inheritance and benefit from it without losing her public benefits. So with all of that, we still get the end credits for Happy Days. Hello, sunshine, goodbye, rain. She's wearing the... So again, I want to thank you all for attending this webinar. Stay tuned. We still intend to do more webinars, and hopefully sometime soon we'll also be able to get back in the community so we can get some face-to-face interaction with some of our seminars as well. But until then, stay tuned for future webinars. Again, not the Tiger King, although there has been some confusion that since Nicolas Cage has been, will seem to be, I think he's going to serve as the role of Tiger King in an upcoming miniseries, and some people mistake me for Nicolas Cage. Some confusion whether it's really me in that role. It's not. I'm not going anywhere. I'm going to continue to be your humble elder law and special needs law attorney. And so I'll just end with one last thing there, and is if we can help with your planning, please don't hesitate to call. We enjoy what we do. That's why I'm not going to be starring in any Tiger King movies anytime soon. I really do enjoy what we do, and we look forward to helping you and your family plan. And in the meantime, take care of yourself and each other.